Dear ladies and gentlemen, welcome again to the analysis of YOLENO TV. I'm glad you're well from wherever you're watching this channel. I'd like to start this session by appreciating you so much. If you wish to support us, please hit the subscribe button and then you can hit the like button.
The judiciary is aiding and abetting executive impunity in Kenya. Dear Kenyans, the judiciary under the leadership of the Chief Justice Martha Koome has today appalled us and made a mockery of its constitutional role by presiding over the 7 a.m. swearing in of the 50 illegal chief administrative secretaries, despite an active case before the judiciary. The case, challenging the appointment of the chief administrative secretaries, was due for a mention today at 9 a.m. The judiciary had numerous opportunities to stop these illegal appointments, but failed to act. Instead, the judiciary, by this stroke, is responsible for aiding and abetting impunity. This action undermines the rule of law and increases the public wage bill, even as Kenyans reel under an economic crisis. When Eliud Matindi and others challenged the chief administrative secretary appointments, the court denied them conservatory orders to protect the constitution. Instead, the court fixed the mention not hearing today 9 a.m. Yet by sunrise, the same judiciary had sent a top official to swear in the 50 illegal chief administrative secretaries at State House. These actions by the judiciary are akin to a wild goose chase.
Now the courts have distanced themselves from the oath that was taken at State House by the 50 chief administrative secretaries. The court seems to be distancing themselves from these complaints because this issue of the illegal appointment of the chief administrative secretary has hit the headlines and most Kenyans are talking about it. This move is putting the Supreme Court in a very awkward position because there is a pending case that was supposed to take place on the same date that this Kenya Kwanza government decided to have this oath-taking session take place. Mind you, the courts are now distancing themselves from this mayhem. But if I look at the way these things were arranged, I still feel that the courts cannot escape this mistake because the courts did not issue a conservatory order that would have barred the vetting and oath-taking of these 50 chief administrative secretaries. That is the first mistake that the court did. Also, the parliament cannot escape this mistake because Speaker knew very well that if they had started the session of vetting, then someone would go to the courts or the courts would hold this process of vetting and then this would eat into their plan. So the Supreme Court and the Parliament are both to blame for this mistake. Let me take you through this whole process so that you can get to understand how it all happened. But before you get there, please take a moment and subscribe to YOLENO TV. You can hit the like button and then you can hit the notification bell so that every time we upload any video, you always become the first person to get notified. Now, ladies and gentlemen, let us face this matter in a more mature and sober mind. First of all, the Supreme Court announced that was last year. They said that the chief administrative secretary was illegal. That was the first move they made. Then the Supreme Court again goes further and says it is okay to proceed with the plan of appointing the chief administrative officer secretaries. The Supreme Court again, after William Samoei Ruto had appointed 50 chief administrative secretaries who are supposed to go through vetting, and after vetting, if they are successful, then they would proceed to oath taking. So William Ruto appointed the 50. A case had been taken to the courts, and the judges were supposed to issue a conservatory order, an order that would bar anything to be done on this issue, the issue of CAS appointments, CAS appointments, the 50 CAS appointments. So the courts were supposed to stop anything on that. If the courts had decided to stop it, then I think vetting would not have started, oath taking would not have taken place. Just stick with me and let's go again. So the courts decided to set a date for hearing of this case, but declines to issue a conservatory order. So the date that the courts, I think that was Wednesday, if not Thursday. So the date that the courts had set aside for this, for the hearing of this case, William Ruto rushes to do the oath-taking process, or rather to conduct this oath-taking, and then that finds that the courts have been time-barred. So the courts hapa, mchezo ni mzuri. Sasa koti imeweka kwamba Wednesday ndio hii kesi itasikizwa. Sawa, kesi itasikizwa Wednesday ama Thursday. Isikumbuke hiyo siku, lakini kesi itasikizwa. Haya, William Ruto kwa sababu yeye ndo rais akaweka hiyo siku ambayo kesi itasikizwa. Kama kesi ilikuwa itasikizwa kama saa 4, akaamua hii oath taking hii ifanyike saa 1, so that like 2 hours away from that time of the court. So that by the time they are done, the courts cannot again stop something that has already taken place. So that's why I'm saying this thing was engineered, and the judiciary cannot run away from this issue. The same to Wetangula. Wetangula alitoa ile decision kusema kwamba constitution A, constitution B haiwaruhusu. Haiwaruhusu kwa nini? The reason why Wetangula alisema haiwaruhusu ni kwa sababu alijua kwamba wakianza ile vetting inge affect ile date ya koti, na kama inge coincide ile date ya koti alafu koti iseme stop, basi ile plan yao haingeingiana. Sasa hiyo ndio maana unapata kwamba Wetangula alijitoa akaachia William Ruto mpira. Koti nayo ikasema haiwezi issue conservatory order because conservatory order ingefanya kwamba hawangeweza kufanya ile oath taking. So koti ika decline, lakini koti ika set date fulani ambayo hii kesi itasikizwa. Sasa hiyo siku hiyo kesi this is no funny. Hiyo siku ya kesi the government decides that watu waje mapema so that wafanye ile oath taking, wamalize oath taking before the time for this case starts. So that's why I'm saying this thing was planned.